SJC-1232222, Commonwealth v. Keith M. Cawthron and another.
Good afternoon, Ms. Cantor.
Good afternoon, Mr. Chief Justice, Your Honors, and may it please the Court. I'm Lindsay Cantor, appearing on behalf of Craig Floodstrom. I'm accompanied today by Attorney Daniel Callahan. In April of 2013, Mr. Floodstrom and Keith Cawthron were stopped by the police in a parking lot of a Longhorn Steakhouse in Tewksbury. As a result of that stop, they were arrested and charged with trafficking oxycodone and with conspiracy to traffic oxycodone. We're here before you today on further appellate review of the Commonwealth's appeal of the motion judge's order allowing the motion to suppress. With respect to Mr. Floodstrom, there are two issues before you today. The first is whether he and Mr. Cawthron were in custody for the purposes of Miranda, whether Miranda warnings were required in this case. The second issue that pertains only to Mr. Floodstrom is his standing to challenge the search of Mr. Cawthron's car.
Can we take the finding by Judge Salinger, not friendly and relaxed discussion? Is that really that important finding, even if you have a Jones-Parnell problem with that finding by the appeals court? When we're applying the four Bryant factors in Groom, that finding goes to one of the four factors, the nature of the interrogation. And look, many, maybe the overwhelming majority of roadside discussions before custody are not particularly friendly and relaxed. So how important is that subsidiary finding here?
Justice Lowy, I would say that that subsidiary finding, although I think the finding was amply supported by the record and should be considered by the court, is only that. It's a subsidiary finding that's a small portion of that factor, which is then only a portion of the ultimate inquiry, which is whether a reasonable person in the individual's position would have felt free to leave. So, although I certainly think that that finding was supported by...
Is that really the standard? Because no one's free to leave when there's a stop. I mean, it's got to be more than simply they're not free to leave. I know we've said that. I know that. I think I've said it, quoting other people. But it has to be some degree of coercion apart from the fact that you're not free to go.
I think there is some confusion inherent in the phrasing, and I was quoting Commonwealth versus Simon when I said that. The ultimate inquiry is whether a reasonable person in the defendant's position would have felt free to leave.
No, it isn't. It's whether or not a reasonable person in the defendant's position would believe that they were in what's the functional equivalent of custody. And this inures to the Commonwealth's benefit, but free to leave is one of the four Bryant factors.
Well, yes, and that's what I was going to say is, it has been phrased in many ways, and in Commonwealth versus Simon, 456 Mass 280, it was phrased the way that I've stated. It has also been phrased exactly the way that you stated in other cases. Whether the defendants were in fact free to leave is one of the factors that goes to the ultimate inquiry about whether a reasonable person would have felt that they were restrained to the degree associated with arrest, or, as put in Simon, whether they would have felt free to leave. So the defendant's feeling about, a reasonable person's feeling about whether they were free to leave is the ultimate inquiry. The actual subjective freedom to leave is a factor in that. And certainly in this case, that factor is met. The officers both testified that these defendants were not free to leave at any point during the interaction. But that, of course, does not answer the ultimate question whether a reasonable person would have felt free to leave. Just because the officers thought they weren't free to leave doesn't necessarily mean that a reasonable person wouldn't. In this case, in the objective circumstances of this case, a reasonable person would not have felt free to leave, would have felt that their movements were restrained to the point associated with arrest.
You know, this is a threshold inquiry, right? There's no dispute until he says you're under arrest, or until they're placed under arrest. We're really talking about a Terry stop.
Until they're placed under arrest, we're talking about a Terry stop, but Miranda custody does not require arrest, and
Yeah, thank you.
I know you know that.
Thank you.
Miranda custody does not require an arrest, and a defendant can be found in custody for the purposes of Miranda in a Terry stop situation. That's Commonwealth versus Gordon. So I agree that what we're talking
He
about
can
is a
actually
Terry
be
stop.
found in custody during a discussion, interrogation, even if they end up walking out the door afterwards.
Absolutely.
So that, it's just one, it's probably the most important factor, but if you get pulled over, at least if I get pulled over, and I'm going 2 miles over the speed limit, and the police officer comes over and asks me for my license and registration, I certainly do not feel like I am free to leave, but that's not custody for the purposes of Miranda.
Well, I think if a reasonable person, under Commonwealth versus Simon, and it is one of the ways in which the standard has been articulated, if a reasonable person would not feel free to leave, then it is custody for the purposes of Miranda. But here we have, it goes far beyond that situation which you might have seen in, for example, the Berkemer case. We go well beyond that in this case. What we have is an armed detective initially approaching these two men, showing his badge, identifying himself as a police officer, and saying, "Stay right there." That's critical. He orders them to stay where they are. Then they wait. They wait for the second officer to arrive. And in the meantime, Mr. Floodstrom blurts out a statement indicating that he knows he's suspected of having done something wrong. He says, "This is how I feed my family." Now, I didn't seek to suppress that. We're not seeking to exclude that statement. But he knows in that moment that he's a suspect already. And Mr. Cawthron hears him say that and knows in that moment as well. Lieutenant Columbus arrives on the scene, also shows a badge, and the detective and the lieutenant, identify the defendants by asking for their identification. Again, that's another indication to them that they're not free to leave, another indication that they're...
The defendants didn't testify, correct?
The defendants did not testify.
You're inferring that the other person heard and knows and all that, right?
Yes, they were both, I'm inferring that based on the fact that they were standing together at the time, But I think the critical moment that makes this unmistakably custody for the purposes of Miranda is the moment where each defendant is ordered around the side of their respective cars by these officers. They're not asked to accompany them. They're not given a choice. They are told. That's the word. The detectives testified. They told them. They took them around the sides of the cars.
Doesn't that happen in almost every OUI with field sobriety tests given? Come over here to the fog line, and we're going to have you do a 9-step heel to toe. And of course, the police officers bring them over there, not just because of the fog line. They want to make sure that no one gets hurt. And we certainly don't say that's custodial.
Typically, they're asked if they'd like to perform field sobriety tests. They're asked if they would like to do that. They're not simply ordered to go perform field sobriety tests. They're asked. I think critically here, the purpose of asking them to move is to interrogate them. We hear that in the testimony at the hearing, that this was a tactic and a strategy, that they were separated for the purposes of interrogating them before they could get their stories straight. They were then questioned in a way that was accusatory. What did you just buy? Again, Lieutenant Columbus said that was a tactic and a strategy to attempt to elicit more incriminating information.
What about this finding that because these police officers were armed, there's inherent force and therefore intimidation? Wouldn't that apply to every single uniformed police officer if we were to adopt something like that?
It would apply to every single uniformed police officer. It is not my impression that was a dispositive factor, that the motion judge was saying because they're armed, any time an armed police officer approaches anybody in any circumstance. It was a factor, the fact that they were armed and that
So if we don't accept that as a proposition, you still think you win?
that any armed
Right,
approach.
if we think that was not a valid inference.
Yes, we still do win. And the reason that we still win is because we have the defendants ordered to remain in place, ordered to move, interrogated in a way that was accusatory. Mr. Floodstrom was given some form of insufficient, but some form of Miranda warnings, which added to the level of formality of the interaction, which conveyed unmistakably to him that he was a suspect. These are the factors from Groom that we analyze, and in this case, we have these factors present. So the fact that in a different case, an armed officer approaching someone might not be sufficient for custody is not dispositive in this case, where there was much more that happened here that resulted in the defendants being in custody by the time they were questioned, by the time they made these incriminating statements.
To get to the Jones-Parnell issue, Judge Salinger makes a finding that Detective Columbus gave Detective Donovan the pill bottle and said where he found it. That all happened in front of Floodstrom before Floodstrom told Detective Donovan that he sold drugs to Cawthron. And if you go to the transcript, what you have is you have Donovan on direct and cross 5 times saying that Floodstrom made the admission to the OxyContin exchange before Lieutenant Columbus showed Detective Donovan the bottle in front of Floodstrom. So I don't know how that subsidiary finding wasn't clearly erroneous.
Your Honor, the subsidiary finding that was made by the motion judge is that at the time that Lieutenant Columbus handed Detective Donovan the pill bottle, and I'm quoting here, Donovan had not yet finished questioning Floodstrom. Not that it occurred before any questioning happened, but it occurred.
The point is that the accusatory statement is the point of the factual finding is by the motion judge that the accusation happens in front of the defendant. And it's before that defendant has admitted to selling drugs.
What the motion judge found was that it was at some point during the questioning of the defendant. The Commonwealth characterized it in that factual finding in its brief as having happened before. But what the judge actually said was it was at some point during. The judge, I believe, felt unable to pinpoint the point at which during it happened, because Detective Donovan's testimony was inconsistent. He first said on cross that he did not remember whether Mr. Floodstrom was questioned and made the incriminating statements before or after Lieutenant Columbus showed Detective Donovan the pill bottle. On redirect by the Commonwealth, he said that the pill bottle happened after the incriminating statements. And then on recross, he said he believed that it had happened after, but that he could not recall. That's in the transcript between pages 47 and page 50. And so I think it's a reasonable conclusion that the motion judge felt the testimony was inconsistent and that the point at which that coercive act occurred could not accurately be pinpointed, and indulging every presumption against waiver of a constitutional right, as we must do under Johnson v. Zerbst. I think that the motion judge then said any of Mr. Floodstrom's statements and his act in taking the money out of his pocket may have been under the influence of that coercive act.
And there's nothing in the transcript that says anything like that. It's clear from Detective Donovan and Detective Columbus's testimony that the pill bottle's found and the statements made before they get to the other car.
I'm sorry.
After Detective Columbus gave Donovan the pill bottle and said where he found it, that all happened in front of Floodstrom, according to the judge's finding in the motion to suppress. But
Right.
That all happened before the statement at the other car with the co-defendant, according to the transcript as I read it.
No. The sequence of events, as I understand it, is that these two defendants were essentially taken around the sides of the cars simultaneously. Mm-hmm. Mr. Floodstrom was given some form of insufficient Miranda warnings, while Mr. Cawthron was asked, "What did you just buy?" Mr. Cawthron said he bought pills. Lieutenant Columbus, talking to Mr. Cawthron, went into Mr. Cawthron's car. He didn't ask, he did it, it seems fairly quickly, although that's an inference. Went into Mr. Cawthron's car, recovered the pill bottle, and then after that walked around to where Detective Donovan was questioning Mr. Floodstrom, showed Detective Donovan the pill bottle and indicated it had been found in the car.
That last part, I didn't see anywhere in the transcript. As a matter of fact, I saw Detective Donovan say antithesis of that 6 times.
Detective Donovan testified inconsistently about when that occurred. He said he couldn't recall, and he said that the handover happened after Mr. Floodstrom had made the statement. So I think Detective Donovan's testimony, I would submit that Judge Salinger did not credit the statement that it occurred, that the handoff happened after Mr. Floodstrom's incriminating statements, because there was inconsistent testimony suggesting that Detective Donovan did not actually recall when it happened. And again, the transcript, the portion of the transcript is 47 through 50, and the actual, the place where he says he did not remember is 47 and 48, and then where he said on recross he could not recall for certain is 50.
All right, thank you.
So if I may just, with respect to standing.
We have to rest on your brief. You're already 7 minutes
Yes,
over.
I was just
so,
going to say, Frazier's dispositive, I'd like to rest
We've
my
read your brief. We understand
Thank you
claims
very
with
much.
regard to the elements of the offense.
Thank you.
Mr. Glynn.
Thank you, Your Honor. Good afternoon, Your Honors. My name is Thomas Glynn, and I represent Keith Cawthron, co-defendant in this matter. The issue for Mr. Cawthron is simply under custody. So just one issue. When reviewing this, the law and the facts of this case, I noticed that the standard of totality of circumstances, I think, is important in a situation like this, where the field encounters between police and defendants is always different. And I think it's important to, some of the Commonwealth arguments, I noticed that they brought up a floodgates argument and case law that is different on some points. And I think that's really difficult to do in a situation like this. On the floodgates argument, every case that comes before you, I would suggest this is no different than a lot of the other cases that have come before you on this issue, is a very unique set of circumstances, a very unique set of, a sequence of facts, a sequence of events that are not going to be affected necessarily by one part of another case.
Help me to get a sense, I mean, to the extent that the key issue is the extent of coercion that a reasonable person would have understood. Is that a factual finding by a judge? Is that a legal finding? I mean, we have mixed issues of law and fact, but the judge has the motion judge has a quite different vision of the coercive nature of this encounter than the appeals court judge did. So how do we evaluate that? Is that a question of law, or is there some mixed issues of fact and law?
Are you talking about for instance, Judge Salinger's statement of an implicit threat of force?
Judge Salinger plainly concludes that this was a relatively coercive encounter, and coercive enough to rise to the level of requiring Miranda. Appeals court says, no, it was not a terribly coercive encounter and does not. Is that a pure issue of law, or, I mean, what deference do we give to the trial court's or the motion judge's findings with regard to the extent of coercion?
I think his facts that he relied upon were in two sets. There were subsidiary findings, and then there were ultimate findings. I would say you do get into the area of mixed facts in law, and I think that the bridge occurred on the not relaxed and conversational in the finding of implicit threat of force. I would suggest to the court that up to that point, these are factual findings.
Now the implicit threat of force is somewhat problematic because, as Justice Gaziano mentions, every police officer who is armed carries some degree of implicit use of force. So what do we do with that?
That's true, and I would also say that I don't think Judge Salinger relied completely on the armed nature of a police officer. I think he was very clear or very careful to list a variety of things that happened, and most importantly, the sequence. And I mean, he talked about the quick approach. He talked about the immediate order to stop. And then he talked about the separation of the two. And I think that sequence makes it much different than just a police officer approaching with a gun. So his finding of an implicit threat of force, I think, was based on that. So it wasn't based on the fact that the officer had a gun alone. And finally, at the end of that sequence, it comes the accusatorial question. Judge Salinger found that up to the point where they were separated, that they were actually in custody at that point. And I would suggest to you that the question of what did you just buy to Mr. Cawthron was very much of an accusation, and different throughout some of the other cases you've seen in the Commonwealth's brief and my brief about questions that were asked. One distinction that comes to mind is the difference between, I think, in DePisa they asked if he had a gun. And it's not against the law to have a gun, and there's a safety concern there. However, in Haskell, it was, do you have a license for this gun? In Callahan, the question was, what is going on and what happened?
Isn't that the inquiry part of the threshold inquiry? And I think that's what the appeals court hung its hat on and said, geez, look at the Terry decision itself. There's an inquiry when we allow police officers, without giving Miranda, to ask people questions. Where you going? What's in your pocket? Things of that nature.
That's correct. The Burkmere.
I'm sure Mr. DePisa didn't like being asked, do you have a gun?
I'm sure he didn't, but Terry is the Fourth Amendment. I don't think it's really, I don't think it's that important to the issue of Miranda.
But right, if we're trying to characterize the nature of this encounter to see whether it rises to the level of requiring Miranda rights, we should look to see the nature of the encounter, correct?
Correct. I think every Terry stop, no matter what happened, you can be analyzed through the groom factors to determine, which in this particular situation, whether or not there was the level of coercion that is necessary that would give rise to the need for Miranda. If this was a Terry stop, I would say it was a pretty high-end Terry stop. They controlled the actions of these two individuals from the very beginning, from the onset, and they didn't let go until the end. And there was a sequence of about 4 very specific events that Judge Salinger did. He heard and he listed in his decision.
All right, thank you.
Thank you.
Mr. Farrader?
Thank you, Your Honor. Good afternoon, if it may please the court. Timothy Farrader, Assistant District Attorney from Middlesex on behalf of the Commonwealth. In this case, the brief one-on-one questioning in a public parking lot does not rise to the level of Miranda custody. And if I can just first address one point brought up by my sister in this case, where she talks about the tactics and strategies used by the police officers. In this case, the tactic and strategy of separating the two, as the officer testified to, was to keep them from getting their story straight. This is vastly different than the tactics and strategies that the Miranda court was worried about that occurs in police station extended interrogations, where the police use tactics to try to impart psychological force and coercion onto suspects to get them to make a statement. This is a very, very different type of strategy that's not meant to coerce the defendants into speaking, but rather just to keep them from just getting the story straight, from being able to hear each other. That's a very different situation. In terms of this case, going to the standard, I know it's been stated a few different ways in the courts. I point the court to Commonwealth versus Cawthron, where this court stated the test is an objective one. Would a reasonable person in the circumstance of the defendant's interrogation have perceived the environment as coercive? And I know it's been stated a few different ways, but I asked the court to look at that statement, because I think that's a good statement, because it goes back to the original purposes of Miranda, which is are the suspects in a coercive atmosphere? And the courts have stated over and over again, both the Supreme Court and this court, that Terry stops, the traditional type of Terry stop, not one where there's force applied or there's a flight and someone has to be tackled in order to be arrested or handcuffed or put into a police cruiser. But a Terry stop like this, where a person is stopped, briefly questioned on one-on-one, just simply doesn't rise to the coercive atmosphere that the Miranda court was concerned with. All the cases where the Terry stops are found to have risen to the level of Miranda custody, Gordon, Damiano, those cases had force, flight, the person had to be physically restrained, put into a police cruiser. This case, none of that happened. The interrogations were brief, everyone was cooperative, the questions were in regular tones.
Well, the problem with being cooperative is you could be cooperative because you could appear cooperative because you were coerced. So I know that the appeals court took meaning from that, but I don't know that I would.
Well, sure, but going back to how the questions were actually asked, the testimony was consistent. I think there was a few different ways they were described: medium tones, regular tones. Certainly not the type of aggressive, confrontational question that this court should be concerned with.
I guess that leads to the next question, which is, can you prevail on Judge Salinger's factual findings?
So,
If we were to accept those factual findings and not endorse the appeals court view that they were clearly erroneous, do you still prevail?
okay, so the first factual finding Commonwealth took issue with was the nature of the questioning. And I think I can kind of recharacterize the Commonwealth's issue with Judge Salinger's finding. It's not that not relaxed and not conversational is not supported by the record. That's supported by the record. It's the fact he doesn't actually make a finding of what the interrogation actually was. And I think this court can supplement the record by the undisputed testimony that the conversation was regular tones, medium, normal kind of roadside conversation.
That's, I guess, the part that concerns me. I mean, you're only going to have a police officer testifying in these circumstances. I know that Judge Salinger said at the beginning, I found the officers to be credible to the extent consistent with my opinion. Were credible and credits their testimony to the extent it is consistent with the court's expressed findings of fact.
Correct.
Which I don't quite know what that means, but I am troubled by a world in which we have police officers who say everything was friendly, and the judge, from all the circumstances, makes the inference that it wasn't really as friendly as the police officer describes. Is that means that judge's finding is clearly erroneous because he relies upon circumstantial evidence to make that finding and doesn't credit the characterization of the police officer, or is that clearly erroneous?
Well, again, saying it's not relaxed and not friendly, I don't think is clearly erroneous, because that wasn't the testimony. The testimony was that it was medium, regular tones, and Judge Salinger actually didn't make a finding as to what it actually happened. And I think there's no dispute on either side that this is the undisputed testimony. It was regular kind of police interaction, and so I think that you can supplement that finding. It's not necessarily that it's clearly erroneous, it's just no finding was actually made as to how it actually occurred.
So
other
if
than
the,
that, how
judge,
it
if the
didn't
judge
occur.
had said that the police officers were screaming, you would say that was clearly erroneous.
That would be
because there's
clearly erroneous.
No circumstance or other evidence that would support that.
Correct. I know I argued in my brief it's clearly erroneous upon further reflection. I think that it's just he didn't make a finding, and I think it's undisputed, and you can supplement the findings in this part. As to the second finding we dispute, when did Detective Columbus bring the pills around to the other side of the car where Mr. Flodstrom and Detective Donovan were? That is a finding that is clearly erroneous. Detective Donovan first testified consistently that he didn't see the pills until after Flodstrom made his statement and handed the money to him. And then further on, Detective Columbus testified on page 68 of the transcript. He found the pills, then he went back to Cawthron, placed him under arrest, and went through that process. So there isn't even really a dispute or an inference that can be found. If Cawthron testified the other way, yeah, once I found the pills, I went straight over quick as I could to Donovan. So the testimony is consistent from both officers. And without some inference or any finding or any evidence to the contrary, I think that has to be a clearly erroneous finding.
But that would matter only if we were to find that it was a custodial stop with regard to Cawthron, because only then would we have the fruit of the poisonous tree with regard to
Correct. Well, it would matter to Floodstrom's statements and
Right,
handing the money.
right, but it
It wouldn't
matters
matter
only-
to Cawthron.
But if we were to find that that Miranda was not required, it doesn't matter when the statements were made.
Correct.
So let's get to the core issue of whether or not Miranda was triggered, and go back to my question. If we were to accept Judge Salinger's findings of fact, as a matter of law, do we say we must conclude that it was not custodial, or do you say as a matter of law, then it was custodial?
No, even on Judge Salinger's facts, this is absolutely not a custodial interrogation. I think I point to the Supreme Court case in Berkmer, where they talk about, this is for all intents and purposes, your traditional, as a Terry stop as imagined by the Supreme Court. They are stopped, briefly questioned in public. The questions were investigatory in nature. So even on Judge Salinger's findings, that this was a not custodial interrogation. Berkmer, well, it started with a traffic stop, has facts that are very, very similar to this case. The defendant was stopped using lights and sirens. He was ordered to exit the vehicle. He was shaky when he got out, brought to the back of the vehicle, asked to perform a field sobriety test, which he didn't do well on. And then that's when the question happened, have you been drinking tonight? And he said I had a couple beers and smoked marijuana. It's extremely similar facts where they're ordered to the side of their car, not a long distance, not really like taking them to a different location. It's brief questioning in an investigatory nature. So I think this clearly falls outside of Miranda, and for all intents and purposes, this is a traditional Terry stop. And if Miranda would apply in this case, it would apply to all Terry stops, and essentially because the Supreme Court has said Terry stops are the same as traffic stops as well.
We don't need to go that far, do we?
I think that would be maybe the unintended consequence.
This is more coercive than some, less coercive than others, but certainly there are other Terry stops which are different in terms of a traffic stop, for sure.
All the facts are certainly different, but I think in terms of their freedom of restraint, their freedom to move has been restrained. That's certainly true in all Terry stops, and in this case, there's nothing really more than that to bring this beyond to Miranda custody. So I don't think there's anything other than just the stop, which would be the same in a traffic stop and all Terry stops. In terms of the questioning, what did you just buy? That's not necessarily a question that suggests illegality. If you look at on page 50 of the record appendix, in Mr. Floodstrom's motion to the court, he lists all the different things that legally could have been happened and bought in the parking lot. From lottery tickets to candy to minutes on a cell phone, that was in the motion, all the different things that could have happened legally. So the police are in a situation where they don't know, they have reasonable suspicion to stop them, but they don't know what's happened. And saying, what did you just buy is not necessarily a question that suggests illegality, because there are a number of things that could have happened there.
But just like guns, OxyContin's not necessarily illegal.
No, and in this case, they don't even know exactly what happened, so it could have been something perfectly legal that could have been bought and sold in that parking lot.
But given the fact that that's not what they thought,
Oh, no.
what's the harm in giving Miranda? What's the harm in having a rule that Miranda would be helpful here? It'd be fair.
Well, sure, but I think the issue in Miranda was that the court was focused on was trying to give some safeguards to the inherently coercive atmosphere of an interrogation, extended interrogation, in a police station where the person's cut off from public, and that in that situation, in those psychological pressures, a person will feel coerced to talk, and that the Miranda warnings are necessary to prevent that coercion. Where on the side of the road, where it's one-on-one questioning, those coercion isn't there, and the person, as they talked about Miranda and Berkmer, still feel free to either not talk, say something not incriminating, or give a confession. So I don't think there's any coercive aspects. Well, there's the coercive aspects of being the police officer, but those are overcome by the nature of being in public in the one-on-one interrogation, where Miranda simply isn't necessary. And requiring Miranda in any interaction between a police officer and a citizen, I think would impart a sense of formality and suspicion, where a witness who hears Miranda and who might otherwise talk might now think that they're a suspect and might choose not to speak in that situation.
Maybe they shouldn't.
I'm sorry?
Maybe they shouldn't speak in that situation.
Well, I think there is a law enforcement purpose of getting witnesses to say what they just saw or what they witnessed, and I think because Miranda is associated with being a criminal suspect, it might impart that on the witness, and they might not speak where they would otherwise interfere with law enforcement in that
And
way.
one of them was provided with Miranda.
Correct.
And what about Judge Salinger's finding that the Miranda warnings were not complete?
Well, I think the issue I had with that was Miranda warnings. That is the Commonwealth burden. And in this case, we didn't have the detective read or say the warnings into the record or put his Miranda card into the record. So I think when we don't do that, we kind of leave the door open to the judge's finding that they were incomplete.
The police officer testified, I gave Miranda, there was no other questions about that.
Correct.
And then the judge says, well, Miranda was incomplete.
I think where we don't have him read it into the record exactly what he said, I do think you kind of leave the door open.
Well, I agree
To
with
that
that.
judge's
I mean, it's a good point. Proof beyond a reasonable doubt is proof beyond a reasonable doubt.
Yeah.
But there was a finding that, that Miranda was not read. And of course, in the transcript,
He said
the
read.
uncontroverted testimony was that it was read.
Correct, but I think this is the same problem, that we left the door open to what exactly was
I
read.
think that's a very fair point.
And then finally, if you just, on the automatic standing point, I just want to make the quick point that this is not a situation where the Commonwealth is trying to have it both ways, where we're saying he doesn't have possession to defeat automatic standing at the motion to suppress, and then saying he does have possession at the trial. The reason we're saying that automatic standing doesn't exist is because the facts led us there. Both defendants stated that the drugs had already been bought and sold, and when the drugs had already been bought and sold, there's no claim that they can be brought by the Commonwealth that Mr. Flostrom had either actual possession or constructive possession at the time of the search, which is clearly the automatic standing rule.
But if you're right, wouldn't you be limited at trial to the distribution element as opposed to possession with intent?
I think we would be, and at the time of the search, yes, but you could, in theory, prove that he possessed with intent prior to handing over the
Yeah,
pills.
but
but-
isn't that the problem, though, that the language of every indictment says all theories, and the defendant fairly says, well, you have a possessory element in there, I get automatic standing.
It's at the time of the search, which means there has to be some sort of factual finding. And in this case, the judge solely relied on the language of the indictment without making any factual finding as to whether he possessed the drugs.
Your
at the time of the
indictment,
search.
right?
I'm sorry?
It's your indictment.
Absolutely.
You caused this problem.
We did.
Right.
So even if you caused it, are you stuck with it, or is there a way out to say, Your Honor, we agree to limit our indictment and only argue distribution as opposed to possession with intent?
So I think there could be a remedy fashion where we are limited at trial to either possession prior to the search or the distribution to Mr. Cawthron.
Possession prior to the search isn't going to help a lot because it's still possession.
Well, no, this happened in Commonwealth versus Mora, where they found automatic standing and apply. A defendant showed a gun to someone, hid the gun, took off, the police come, search, find the gun, and so the possession of the gun in that case was when he showed it to the witness. So that is possession. So that is a possession case, but it was possession not at the time of the search. And the Commonwealth could still move forward on the possession of that firearm.
All right, thank you.
Thank you very much.
Court, all rise.